Hi, my name is Brittany Jones, and you're watching Legal Access on WMBF, brought to you by McGuire Law Firm. Today we're here to talk about workers' compensation law. This is a show where you call in live and we answer your questions live on the air to give you information on different legal topics. So, like I said, we're talking about workers' compensation today, so get in your questions early. The number to call is on your screen. It's 843-848-8080. And I'm filling in for Dave today. He's under the weather, but thankfully we've got a panel of other attorneys with me. Also, my boss, Mr. Ian McGuire, always a pleasure.
Good to see you.
And our friend Josh Koshin from the O'Neill Law Firm.
Correct. Yes. Thanks
Glad
for having
to
me
have
back.
you. Yeah.
Yeah, Brittany, I don't know if I'm your boss at this point. Partners, and I do what I'm told most of the time, right? But it's great having Josh with us. Josh's been on the show a number of times. His partner, Rick O'Neill, from the O'Neill Law Firm, has been on countless times. And of course, Josh, you practice in the areas of personal injury and you do some criminal defense as well. And of course, our topic today, which is workers' compensation. And so we're well equipped to answer any questions, as Brittany said, in regards to workers' compensation with Josh here. And the number is 843-848-8080. That's 843-848-8080. Josh is also a adjunct professor over at Coastal. He teaches business law over there and does a great job, and he's an excellent attorney. So we're happy to have you back with us, Josh. Thanks for being here.
Yeah, so let's, I guess, just start at the beginning, right?
Yep.
Say that you're at work, you get hurt. Step one, what do you do?
Want me to take it?
Please.
Okay. So, well, I always tell my clients the most important thing is to put something in writing and give notice to your employer that you're injured, okay? The law says you only have 90 days to do that, but I think the sooner you do that, the better. From that point, the employer will usually fill out an injury form and direct you to your appropriate medical treatment and send you where you need to go. Obviously, some of that stuff doesn't happen right away. If it's an emergency situation, you kind of get rushed to the hospital or wherever you need to go. But those are the basic first steps I would tell my clients to do.
Yeah, and one thing you said that I think it really permeates through any kind of business dealings or anything you're doing is put things in writing. I mean, now with emails and texts, those work, those count. Later on when you're going back and you say, I did this or did that, it's just wonderful to be able to pull out a text or an email and as opposed to having a he said or she said of whether the call was made or that conversation ever happened. So I think that's great advice. Always make it easy on yourself and put something in writing. And writing now is easier than ever, right? Because we
So
just
true.
text or email.
Yeah. So 90 days is when you're supposed to let your employer know, right? How is that different for filing a claim purposes?
Yeah. And 90 days, we always say that's a notice requirement, and it's a requirement, but from a practical standpoint, you don't want to wait anywhere close to 90 days to let your employer or the insurance company know that you suffered an injury at work. There's no reason to. If it goes that long, you might be okay, but there's probably going to be some skepticism about whether or not it's a viable claim. So make it easy on yourself and do what Josh says and get that filed as quickly as possible. The difference between a notice requirement and actually filing a claim, you generally have 90 days for notice, and there's exceptions to that. So if you feel like you missed that, talk to an attorney. And of course, you have to file a claim within 2 years, which if you go to an attorney, the first thing the attorney's going to do is get some kind of claim filed. You could always amend that or put addendums to it, but something will get filed. You don't, again, right, Josh, want to wait till you're on the edge of that 2-year limit. And again, there may be exceptions to that, but get the claim filed as well, right?
Right, and I think South Carolina on the notice requirement is more than favorable to an injured worker.
Yeah.
I know other jurisdiction, I think North Carolina, maybe 30 days you have a requirement to notify your employer. But I've seen cases where sometimes people fall or something and they maybe have to catch their breath or they're not really sure that they suffered an injury, and they go, hey, a job needs to be done and I need to finish it. And then a week or two goes by and they realize, oh, something's not right. I'm still having abdominal pain or knee pain or whatever. So I think in those situations, you obviously have a lot of time to go ahead and give your employer notice. I still think even if you have something minor and you're not really sure if you're hurt or not, it's probably best to go ahead and text your employer if they're not on scene with you, or notify them by phone. Obviously, you want to have it in writing, but
yeah, and exactly. If nothing comes of it, if 2 days later you're feeling great, then you just move on. But at least you've protected yourself. I think what I've seen with clients sometimes is that they're concerned that they're going to put themselves in a bad position at work if they file a claim, and they're scared to do it for that reason. And that's understandable depending on the company and the size of the company, how long you've been at the company, how serious your injury are. All of those are understandable, but I would at least, if you have a significant injury, sit down with an attorney, even if you don't hire one, even if you don't file a claim for whatever reason, but you want to know what your rights are. The employer is going to have, and certainly the insurance company is going to have attorneys giving them advice on what the right thing to do is. Would you agree?
Yeah, I agree. And I also, from an employer perspective, even if somebody gets a little banged up and they say, hey, look, boss, I'm okay, I think I'll be fine, I can finish the job, maybe you want to be proactive and go ahead and send them to an urgent care just to be checked out, to just make sure that there's nothing more serious going on. Because in these claims, the sooner that you get the medical treatment, the better. It can prolong, if you prolong it,
sometimes
you have
the
more
injury gets
complications.
worse.
You could have infections. You could have, a numerous number of medical problems. So I would say, from an employer perspective, don't always take your employee's word for it that they're okay. Maybe go ahead and send them to get checked out. Now, I'm not an employer of anyone. I work for someone, but you're an employer. Would you say that's pretty good advice from an employment?
Yeah,
perspective if you're an
100%.
employer?
Absolutely. You want to be proactive, and we want our employees to be taken care of, and,
Right.
and as part of the culture, and be back at work
Right.
for their sake and ours, but mostly to make sure that they're healed and okay. And it's just like you said, the longer things
If you
go,
delay,
the delay is sometimes the injuries worsen, and the problems that were small now become big.
And
So
instead of being out for a couple of days, maybe they're out for 2-3 weeks, or maybe more. Maybe they need some
Yeah.
kind of procedure or something.
So better to act soon, whether you're the employee or the employer.
Correct.
Better to act soon to get those
yeah,
things
and
taken care of.
with workers' comp, what we see all the time is the employer and the management and the employee are so much of the time on the same page and in agreement, and the employer just wants what's best for the employee and vice versa. And then the insurance company may not be completely aligned with the employer. They're actually, it's the insurance company might be pushing to get somebody back to work, and
Seems to be a conflict there sometimes.
and so it's a lot of times it's not the employee and the employer that are at odds. It's the insurance company.
That makes sense. Good advice. Well, we're going to go to a quick break, and we'll be right back answering your questions about workers' compensation. Hi, I'm Brittany Jones, and you're watching Legal Access. I'm here with Ian McGuire and Josh Koshin, and we're talking about workers' compensation law today. Next week, though, we're going to be talking about criminal law, so if you have questions about that, feel free to go ahead and email those in now, and we'll make sure that they get answered on the air next week. While we were on a break, we had a caller who phoned in, I think wanted to maybe remain anonymous, but believed she was injured at work and underwent a medical procedure. And then she had some allergic reactions or side effects to that procedure that she had done. Is that treatment for those side effects or that allergic reaction, is that something that would also be covered under workers' comp?
Typically that is covered. So if you have an initial injury and any of your treatment from that initial injury is related to that initial injury, if you have side effects from medication that is being used to treat you for that injury, there may be a little bit of a fight with the insurance company or the employer or whoever to get it approved, but I would say 9 times out of 10 that is something that is covered, even if you have to put up a fight for it. So.
Okay.
Yeah, and we've had cases over the years where somebody might have a left knee injury, and they're overcompensating for that injury, and then it causes injury to the right knee, or it causes a back injury. If you could demonstrate a causal connection between the workers' comp incident, accident, and the ongoing injury or problems that occur, even if it was not initially problematic at the time of the incident, it should be covered. Workers' comp in that respect is supposed to be liberally construed in favor of the injured worker. Without getting too deep into workers' comp history, but when it started, there was a lot of give and take, and things like that should be liberally construed for the injured worker, but there's limitations, right, Josh, on what you can recover. There's technically, while you're recovering, you might have a 2-year recovery, all that pain and suffering that would be a part of your claim if it, say, was a automobile accident or a fall outside of work. Those things you'd be entitled at least to make an argument for pain and suffering, loss of enjoyment of life. Those things are not generally a part of a workers' comp case unless you can show it goes to the permanency of the injury. So there was a lot of give and take with workers' comp, and I know that causes frustration sometimes, right, with our clients, especially the ones that have serious injury, because there are parameters that we have to work through and around, isn't that?
Yeah, and I think the clients that we have that don't have any type of fault in the matter, that is a little bit harder for them to harder of a pill for them to swallow. But like you said, there's give and take in the Workers' Comp Act. So one of the things, like in car wrecks, you have to prove is fault, but in workers' comp you don't. It's a no-fault system. So all you have to prove is that you were an employee, basically, and that you were hurt on the job, and for the most part, you should be covered. There's defenses and there's exceptions to that, but that's typically how they work. So
I mean, it could be your mistake at work,
Right.
and if it was a mistake and not intentionally, it's going to be covered.
Right.
And workers' comp generally, they'll provide medical care a lot more quickly than it would be in a case where you were injured,
Right.
in a car accident or that kind of thing. So
And just going back to the old days, like you said, before the Workers' Comp Act was passed in South Carolina, I'm told that a lot of the employees were actually suing their employer, and they had a lot of lawsuits, and it was just hard to do business that way. So that's one of the reasons that the act is in place, is to help kind of streamline this treatment and get people better. And I know that there's all kinds of complaints, and I know probably a lot of your clients have the same complaints, but that it goes slow and it's not as quick moving. But it is a system devised to help people recover if they have an on-the-job injury, regardless of fault.
Yeah, and if it goes outside the umbrella workers' comp, it may be more difficult for the employer, like you said. If somebody is found not to be in the course and scope of their employment, but the employer was negligent and it caused the injury, as Josh mentioned, they may have a lawsuit if it's not falling under that umbrella workers' comp. So a lot of times the employer is better off putting in a position where it's a workers' comp injury as opposed to a third outside injury.
That makes sense. And so, we're talking about workers' comp is meant to benefit both the worker and the employer, right? In a lot of ways, but it seems like one of the big hangups that people talk about a lot is, my boss might not want me to file under workers' comp, or I'm worried that I might get fired if I file a claim under workers' comp. What do you guys say to that?
So an employer is not allowed to retaliatory make a retaliatory action and fire you because you filed a workers' compensation claim. Now, what I always caution my clients about is, hey, during this workers' compensation claim, you need to still continue to be a model employee. You want to show up on time, you want to dress appropriately, you want to do your job duties, to the best of your ability. And that's a situation, obviously, where somebody is still able to work and they're not completely out of work, right? Because they could fire you for just about anything. A lot of people know this South Carolina is a right-to-work state, so you can quit at any time you want, and the employer can fire you for any valid reason that's not unlawful.
Yeah,
So.
in fact, you can get hurt at work, you can legitimately be out, the doctor has you out, and if a company might have a policy where somebody's out of work for 180 days, and they'll just send you a letter while you're out on workers' comp that you've been terminated or let go, whatever words they put on. But they will actually say, we're letting you go because you can't work and the injury is work related. They can do that. That's
Right.
not retaliatory. That's unfortunate, and it
They need to fill the position.
Yeah.
They still are running a
yeah.
business. So.
And for the injured person, it might benefit their workers' comp case. They said, look, because of this, I lost my job. But I think it's surprising to people that when that happens, that they've and it seems sort of harsh or callous or cold, but it does happen.
Yeah. So we have a caller on the line, Sam from Georgetown. Sam, thanks for calling in. What's your question?
Yeah, thank you. I got hurt on the job a couple years ago. Went to a deposition 2 weeks ago on Myrtle Beach, and I was out of work for almost 14 weeks. They paid me for six weeks, but they owe me for another 7 weeks, and they want to settle the case, but they don't want to pay me for lost wages and stuff like that. So how do I tackle this issue?
Now, were you working was this a work-related injury?
Yes, sir. Yes,
Okay.
sir.
Yeah, well, I mean, you want to
Yeah,
tackle
so
that?
I mean, typically, as long as the doctor puts you out of work related to the work injury and says you cannot do your job duties, then you should be compensated for that. One thing we haven't mentioned so far is how you're compensated. So
Yep.
if you're making $1,200 a week before taxes, the workers' comp system compensates you at 2/3 of that of your average weekly wage before taxes. So in that situation, where if you're making $1,200 a week, you'd be making $800 a week,
Which would not be taxed, just so
and that would not be taxed,
Yeah.
correct? So as long as the doctor's ordered you out of work for 14 weeks, if they've only paid you for 6 weeks and they owe you another 7 or 8 weeks, I think that's something that you should definitely pursue and ask them to be paid for.
And you should also, if you have any kind of permanent injury, you should be compensated for that as well. So, it might not be a bad idea for you to at least consult with an attorney and find out and make sure that you're being treated fairly and properly. But I wish you the best of luck with it.
Yeah. And so as far as consulting with an attorney for workers' comp, that's something that typically, is there a fee for coming in and going over the case with you?
Yeah, that's a good question. Most attorneys in fact, just about every attorney I know that does workers' comp, they'll charge nothing for a consultation, but a percentage or contingency for the settlement. So say you were offered a settlement, it's late in the game, usually it would be a percentage, a third over what the offer was. Is that pretty much how you understand it with most attorneys that do this kind of
Yes,
thing?
and we do that too. We do free
Yeah.
consultations. We'll sit down and meet with you for 30 minutes, an hour, hour and a half, however long it takes to kind of guide you through the system, give you the background, and let you know what we could do for you. And oftentimes, clients will come in and say, well, what do you think? Do you think that I have a case here? Do you think that I'm able to get compensated for this or that? And I'm always cautious about telling them, about their compensation from the get-go, besides telling them, hey, you definitely have a claim and you can explore X, Y, and Z benefits in pursuit of that claim.
Yeah, and I know we've got to run to a break, but yeah, it makes a lot of sense to sit down with someone. A lot of times we'll sit down with someone and and we don't take the case, but we could still give some information to them that might be helpful to their case. So
Yeah.
do that.
So definitely worth it to still sit down with someone even late in the game.
Especially since it's free.
Especially since it's free, yeah. So we're going to run to another quick break, and we'll be right back to answer more of your questions. We're back with Legal Access, talking about workers' compensation today. I know earlier we talked some about getting medical treatment and that your employer might send you, or maybe should send their employee to a doctor. How does that work? Do you get to choose your doctor? Can I go to my own doctor? How does that work?
So no, as part of the give and take in the Workers' Comp Act and the system, your employer is paying for your medical treatment, so they direct your treatment and they send you to the doctor that they have in their network, and really it's really directed more through their workers' comp insurance provider and who's in their network. So you don't get to pick your own doctors. I have seen in some rare instances where an employee has said, hey, I want to go to this doctor, and then there's been a mutual agreement to do that. But for the most part, if the employer says, hey, you got to go to this doctor, then that's kind of who you're stuck with, at least from the outset.
Yeah, and now what happens often is, you know, the attorney will send the injured worker to an independent doctor to get another opinion or second opinion. Another thing is if the employer denies, you know, that the claim's viable, then you go to your own doctor, and then you go to the hearing, and then the commissioner finds that it's a compensable case. Then at that point, you know, they may have lost their right maybe to direct treatment, but generally, yes, it's unfortunately sometimes. But you know, and most of the time, these doctors, they're not workers' comp doctors. They're just doctors, like you said. They're in the network of the insurance
urgent
company.
care earlier,
and they're
yeah.
just trying to get the person better. So there's really less problems than you think with that. I find, don't you? Yeah.
Yeah, I mean, the one problem I do find with clients is if their employer denies the claim and they try to go treat on their own with their family doctor or an urgent care, and they try to use maybe their own health insurance, and that gets denied as soon as they find out it's a work injury.
Yeah.
So at that point is usually when I get clients and injured workers to come to my office
right.
to try to troubleshoot that and figure it out. The one caveat of sending someone for an independent evaluation or a second opinion is that obviously you are paying for that.
Yeah.
Sometimes the attorney may be able to pay
Make it
for
a
the cost of
cost,
an evaluation up front, but it would come out of your eventual settlement benefits.
So if you have health insurance, sometimes it's put on that, and then as Josh says, other times your attorney can use it as a cost to the file, so you're not paying it up front, but it's going to come out of the settlement.
Got it. Well, thank you, Josh and Ian. Thanks so much for chatting with me today about workers' compensation. Thank you all for tuning in and watching and calling in with your questions. Next week, we'll be back here at the same time at 11:30 to answer your questions about criminal law next week. So call in to Legal Access, brought to you by McGuire Law Firm. Thank you so much for watching.
See you next week.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal advice. Please contact and retain an attorney in order to obtain case-specific legal advice.